Hello viewers, today we try to understand the origin, nature, development of the law of torts, how this law of tort is developed in India. As we all know, the law of tort is start with the France and it was developed flourish into the England and then it was borrowed to the India. How it is borrowed to the India? So when the England rule over the India, so they come with their laws, the policies, and various principle which was developed into the England. Basically, the law of tort, though it was developed under the English law, though it was developed by the England, but the root of the law of tort is from the origin from the France. Now, development of the torts. How this particular development of the tort is come from the France to the England, England to the India. As we all know, the Norman conquest of English was invasion of the Kingdom of England by the William the Conqueror in 1066 at the Battle of Hastings and the subsequent Norman control to the England. Now, under the France the legal system, the legal system under the France was disorganized. Why it is disorganized? Because this particular laws or the policies which was developed under the France, it was based upon more or the less it is based upon the customary practices and the customary laws which was prevail at that time. So basically, the trial is conducted more or less on the case basis. Whenever any case is come before the court, whenever any case is arise, so that particular case is decided by the jury or by the particular judges. Now, these judges were appointed at the village, and this they visited to the village. They heard the cases, and accordingly, by hearing the cases, they try to decide the dispute between the parties. Now it is based upon the informations, it is based upon the facts, and it is based upon the what we called as, and it is believe on the impartial of their own court's findings. Now, accordingly, according to the decisions given by the jury, according to the interpretations made by the judges, according to the facts and circumstances, the legal precedent was developed under the France law and then it was borrowed to the English. Now, English legal system is more or the less is based upon the French legal system, and that's why if you see under the law of torts, then you will find so many French terms, French languages, and the French terminologies which is used under the English law. So, the English, as per the English law, the dispute settlement is was based upon the precedent, the custom, the principle of justice, the principles of equality, the principles of equity, and the principles of good consciousness. Basically, the English peoples try to decide the cases or try to decide the dispute between the parties, which was based upon some precedentary rules which was developed by the courts earlier. Sometimes this particular dispute were based upon the customs, and the jury or the judges try to understand this particular problem and they decide as per the customary practices which was prevailed during the that particular British period. The most important thing is that when this particular laws was interpreted, the jury or the judges use the principles of justice, equity, and good consciousness. What is justice, equity, and good consciousness? Justice means the principle where it gives the equal rights or the equal liabilities. So far, the principles of equity is concerned, which is based upon the person's need or the person's qualifications, or it is based upon the person's deserve. And this particular interpretation was based upon the good consciousness of the judges who deal with the particular cases. Now, after considering the rule of precedent, the customary practices into the society, the principle of justice, the principles of equity, and the principle of good consciousness, the majority jury decide the particular case. Now, once the case is decided by the jury or judges or by the court, so it becomes a rule, it becomes a law, and that particular law was applicable into the next cases or the similar cases which arise or which come to the court of law. Now, basically, Initially, the development of the law of tort is based upon the precedent, and according to the need, according to the necessity, according to the new problems which is come on the record, this particular precedent was changed, and this precedent was borrowed from the English law to the Indian law. If you see the Indian cases which was decided by the Privy Council earlier, or if you see the cases which was decided by the Honorable Supreme Court and the various high courts into the India, then you will found the flavor of the English rules or the English precedent or the rules which was developed by the British or the English law. Now, what's the basis of the tort? Why we call the tort is unwritten law? The tort is why it is so, because it is based upon the four components or the four basic principles, what we call as a justice. Secondly, the equity. Third is a good consciousness. And fourth is a judgment. Basically, if you see, the law of tort in India is not written law. It is based upon the principles of justice, the principles of equity, and the principles of the good consciousness. What is the good consciousness of the judges while they are deciding the particular cases? And finally, it is based upon the judgments which is taken by the court in a previous cases. So if the particular court decide the particular principles or decide the particular case, so it is a blend of this particular four things. If you see, say for example, the Reliant versus Fletcher's case, or there are so many other cases where you will found instead of the unwritten law, the dispute between the parties was settled, was decided, and more or less it is based upon this particular four principle, that is justice, equity, good consciousness, and the judgment. Now, what is justice? We need to understand the concept of the justice by considering this particular three components where it provides what justice means. So basically, the concept of justice is based upon the rationality. What is that rationality? So whenever any case come to the court of law, or whenever the any judge is supposed to decide the particular case, he must be a rational. He is not supposed to bias. He is not supposed to favor to any other persons, or he is not supposed to favor on the basis of the custom, on the basis of the religion, on the basis of the person's quality. So when the particular judge or the jury is rationally thinks, so more or the less he is doing the justice with the particular person. If the judges or the jury or the court is a impartial or impartial, so the concept of justice is supposed to be developed. Now the second component is that, so justice means what? To give the particular persons as per what he deserves. If the persons deserve the particular things, how we are supposed to decide how the person and what the person is deserved is based upon the fact, circumstances, situation, as well as the wrong which is committed by the persons and the loss which is sustained to the person. So considering the principles of rationality, if we rationally think what the person is deserved, if the person is deserve the punishment, if the person is deserve the justice, if the person is deserved for to pay the compensation to the other, so as per the involvement of the particular person into the particular case, so the justice will be done. And the third and most important thing is that the treatment, it is the treatment is not the case where the particular judge or the jury or the court treat the persons into the court of law. Treatment means what? That is how you just treat the case, how you just treat the particular parties into the court of law, on what basis you are deciding the particular case, on what basis or on what evidence, on what proof the particular case is decided. So combinations of the rationality and the persons what he or she deserve into the court of law, basing on the fact, circumstances, and situation, and how the court treat that particular case, it is a combinations of these particular three things. It shows the justice is given to the persons. Now coming to the second part, that is the equity. There are the two terminology which is used under the law. Of course, you see under the Constitution of India, where you found the principles of equality. Whereas under the law of tort, apart from the principles of equality, we use the principles of equity. Now, what is the principles of equity? So, the principles of equity having the three important components. First is the persons must be a impartial, the person must be a fair, and the act of the person must be a just. So, if the person says that whenever he's supposed to doing the justice, so if he is a impartially think or impartially consider what the person is deserved, whether it is fair for that particular persons, whether giving the particular amount of compensation, avoiding the punishment to the particular person, whether it is fair. So how we are supposed to decide the concept of fairness? So the fairness is based upon the various aspect, the liability of the persons, the involvement of the persons, the intention of the persons, and so on. And when we think this particular thing is fair for that particular persons, so we need to understand whether it is just, whether it is justifiable to give the particular kind of remedy to the person. So combinations of impartiality and the fairness and the just, which make the persons is a equity. If you see this particular diagram, then you will found then the equality, the principles of equality says irrespective of the person's deserve, every person is equal into the eye of law. Whereas the equity says the person must get as per his or her need. If you see this particular diagram, so the particular person's is need as per the ability and as per the need which is necessity to make the equality among all these peoples. Now the third is that is the good consciousness. How we are supposed to define the good consciousness? So basically the good consciousness is a basis of the thoughts. So as we know, that is there are the two things what we called as there are the people's heard the bad things and the good things. Now it is the judge, now it is the jury, now it is the court who decide what is right, what is wrong, what is bad, what is good. Now when we talk about the what are the bad principles or what are the bad things on which the judges are supposed to decide the particular case, if the particular thing or the particular case or the particular fact is shows that particular thing is immoral, it is a wrong, and it is an unfair, so we say that it is a bad. And if the court is of opinion that this particular things are the bad, so he use his good consciousness, that is because the persons having the ability to think whether it is right or whether it is wrong, whether it is moral or whether it is immoral, whether it is fair or whether it is unfair. So the distinguish between the morality and the immorality, the distinguish between the wrong and the right, and the distinguish between the unfair and the fair. If the person is able to distinguish between this good or the bad things while dealing with the particular cases, while dealing with the particular dispute between the parties, and if he is able to separate between the moral things, immorality, between the wrong and right things, between the fair and unfair things, then we may say that the judges use the his or her wisdom and good consciousness, and basing on that particular good consciousness, the particular court or the particular jury or the judge decide the particular case as per the basis of the good consciousness. Now how this particular judgment is affect, or how the judgment is a part and the parcel and the basis of the law of tort. So what is the order of the court, what we see, and how this order of the court are based upon the judge's self decision. As we know, that is the whatever the order given by the court of law, it is a blend, it is a combinations of the ability, capacity and authority of the judges. If the judges having the ability to think critically, to distinguish between the right and wrong, if the judges are having the capacity to distinguish between the rights and wrong, basing on the legal principles, and if the particular judge or the particular court has the authority to decide that particular thing, then we say that the judgment is a good source of the torts, or it is a basis of the law of torts. Now, how the order is passed by the court of law? So, whatever the order which is passed by the court of law, it is based upon, it is as per the law. What the law says, what the legal principle says, what the definition says, what the explanation, what the proviso clause says. So, by after considering these particular laws, the court order is declared. But as you know, the tort is an unwritten law. So when there is no law, there is no specific provision, there is no written law under the law of torts. So when the judges interpret this particular law, so these particular judges or court must have the ability to interpret the law in a very sensible manner. What is that sensible manner? When the particular judge or the court has ability to interpret the law by applying the good consciousness, by applying the principles of equity. So accordingly, that particular court or that particular jury is able to take the legal action against to the persons. Now the judgment is a combination of what? The judgment is a combinations of the law and ability. It is a combinations of the sensible conclusion of the law, which is based upon the capacity of interpretation of the judges. And when the judges is supposed to take the legal actions, so at that time the court must possess the authority to pass that particular order. So my concern is with the jurisdictions of the court, the power of the court. So it is judgment is nothing but an to rationally decide the matter basing on the facts, circumstances, and evidences. Basing on that, that particular court pass the judgment. Now, these are the basis of the torts. Now, how this law of tort is developed into the India, as we know all, that is the law of tort is a origin, or it is based upon, or it is the principles are origin from the common law. What is that common law? Which is primary is the English law of torts. So it was developed through the English and it was flourished into the India during the British regime or British period. Now, the tort is a selectively enforced in Indian courts if the suit is filed. So, as you know, that is there are some torts which is come under these the substantive law. Say, for example, the defamation is covered under the BNS now. Earlier, the Indian Penal Code, and there are so many other civil remedies where this particular person has right to file the suit and take the appropriate action against to the wrongdoer. But under the law of tort, there are apart from the specific tort, say for example, negligence, nuisance, battery, like that. Apart from this particular specific law, there are so many wrong actions which is committed by the persons where the particular person is supposed to file the suit into the court and they may enforce their legal remedy by way of filing the suit. Now, the term tort has existed since the pre-independence period. It was undeveloped. Why it is undeveloped? Because if you see the development of the law under the Indian scenario, then you will found that the codifications of law was started after the British regime. So basically, when the tort was borrowed from England to the India, so at that time this particular law was underdeveloped. Why it was underdeveloped? Because this law was uncodified. These principles was developed in the France and in England, and it was based upon the justice, equity, good consciousness. Whereas under the in the Indian legal system, where we are follow the principles of custom, the principles of religion, and the various set of principle which is developed by the then king. Now, considering these particular differences, that is the one law which is developed by the Britishers, it says it is based upon justice, equity, good consciousness, whereas under the Indian jurisprudence, Indian criminal law jurisprudence, where it was based upon the religion, where it is based upon the customary practices, and so on. So, due to that, there was a conflict, and because of that, this particular law of tort was underdeveloped before the pre independence period. Now, there is no place under the personal law. So far, the tort is concerned, there is no place under the personal law. And the Indian courts, before making any application of the law adopted from the English law of tort, see whether is compatible with the Indian culture and the circumstances or not. As I told you, This thought is based upon the justice, equity, and good consciousness, where the Indian culture, where the Indian legal system is based upon, or it is a blend of various cultural practices, various the circumstances, various the rituals, various the religious principles. So many a time the conflict was arise between the application of the law of tort so far the India is concerned, because we are not supposed to accept this particular principle, because our legal principle which was based upon custom, religions, and traditions and usages, with this kind of the things this kind of the things we did not that is an accept the provisions under the law of torts. Now coming to the development of the law of torts in India, as you know all, by the Charter of 1726, where the Britishers established the mayor court in the presidency town of Bombay, Madras, and the Calcutta. Now, these mayor courts was commonly applicable to all laws, which is made applicable into the that is in a due course of time. So, the mayor court having power to decide the dispute between the parties as per the common law which was applicable to the particular presidency towns. And at the very same time, this particular mayor court has taken a due care about the that is the conditions and the customs and the tradition in India. So basically, the mayor court was worked on the twofold, or one we say that it is on two sides. The first, the law which is given by the Britishers for the smooth functioning of their day-to-day businesses, and secondly, at the very same time, these courts are supposed to consider the conditions, the custom, and the traditions of the Indian societies. Now, when this particular mayor court tried to settle the dispute between the parties, though it is a criminal or it is civil or whatever the nature of the dispute between the parties, so they always consider the differences between the common law and the custom and the traditional practices which was prevalent to the India. And as you know, the preference was given to the conditions, the customs, the religious practices, and the traditional practices which was prevail in India. So basically, the law of tort was developed, of course, during the after the Charter of the 1726 by way of in the presidency towns of Bombay, Madras, and Calcutta. But it is simultaneously developed with considering the various conditions, various customs, various traditions which was prevail into the India. Now, why the law of tort is not developed in India? Because as you know, as I told you, that this particular law is unwritten law and it was not accepted by the Indian society because of our traditions, our customary practices, and so on. These are the few reasons where this law of tort is not developed so far the India is concerned. The basic and the foremost reason is that the law of tort is not codified. This law of tort is based upon the principles, the judgments, the precedents, and the interpretations made by the court of law. If you see under the law of tort, so you did not found any codification so far the law is concerned. Of course, there are some principle which was earlier under the part of torts, is now is a part of the some codification under the various laws. Say for example negligence, say for example nuisance, say for example trespass. Now these specific torts are codified under the different laws, but there is no specific codification so far the law of tort is concerned. Second reason is that there is a ignorance of law on the part of this the Indian people. Why it is so? Because we have the habit to follow the law which is in written form. So basically, the law of tort was not codified. It was not written law. It is based and it is flourish on the basis of the various judgments and precedents. So due to the non-codification of this law of torts, there is a ignorance of this law of torts among to the common peoples. Thirdly, the third important thing is that is poverty. Due to the poverty, the peoples are not that is easily willing to file the cases for the small torts. if there is a wrong which is committed by the person, so the peoples have habit to settle the dispute between them by way of the amicable settlement. So due to the poverty, the peoples are not aware, the peoples are not easily ready to file the case against to the particular peoples or against to the wrongdoer who commit the torts. So due to that, there is a less number of cases which is filed by the people, and due to that, this particular law was not well developed or well flourished so far India is concerned. Now the another reason is there is a lack of political will or the lack of the political powers. So the political the political parties or the political power did not try to define or did not try to codify this particular law. Now, the next is that expensive and the delayed justice system or the judicial system. As we know, in India, there are the thousands of cases which is pending from the Mufasil Court to the Supreme Court of India. So that there is a very what we called as the pendency of the cases. Due to the pendency of cases, if suppose I suffer the small loss, or if suppose there is a tort is committed against me, if suppose there is a wrong is committed me, so what is my thinking? If I go to the court of law, so it will take years together to get the justice. So the delay into the judicial system or the pendency before the court of law, it is another reasons where the law of tort is not developed so far the India is concerned, because it is also it is a uncodified law. There is a ignorance of the law on the part of the people. There is a poverty, and due to this particular reasons, people is of opinion that if we file the case into the court of law, so it will take years together to get the remedy. So instead of going to the court, because the court is already overburdened, so let's settle the dispute by way of the amicable settlement between the parties. And the last reason is that there are so many civil laws or the civil remedy which is available. Say, for example, we have the remedy under the Contract Act, we have the remedy, civil remedies under the Sales of Good Act, Consumer Protection Act, and so on. So whenever any wrong is committed by the person, and if the people is of opinion that this particular remedy we may get under the different laws. Say for example, there is a defect in the goods, deficiency in service, or if suppose there is a breach of contract. So the person has a choice to file the case as per the codified laws. So the remedy which is available for the tortious act is having under the different various civil laws. So the people used to prefer the codified laws to get the remedies. Now, considering this particular reason, and there are so many other reasons also, but primarily these are the important reasons where the law of tort is not flourished, it not developed so far the India is concerned. Now, what is the tort? Now, what is the by considering this the development of the tort, by considering the essential elements of the torts, how we can suppose to say what is the nature of the tort? So, what other words we can say that is tort? The tort means it is a civil wrong, it is a actus reus, it is a misconduct, it is a misconduct on the part of the persons, it is a wrongful act, it is a wrongdoing, or it may be we can say that that is called as a wrongful conduct. In short, we may say that the tort is nothing but a civil wrong, or it is a wrongful conduct of the particular person at the given fact or given circumstances. If I commit any wrongful act, if I do any wrongful act which leads the violations of the legal rights to the others, if it cause the harm to the others, if it cause the injury to the others, then we may say that it is a simple tort, or it is a tort within the definition. Now, what is the difference between the torts and the other law? If we compare the law of tort with the criminal law as well as under the Contract Act, then we will found that there are the differences between the law of torts and the criminal law as well as the torts and the contract. Now, so far the tort is concerned, it is a private wrong. Why it is private wrong? Because under the law of torts, the particular persons who commit the wrong is responsible under the law. Suppose, for example, I commit the wrong against to the any XYZ person, so he has a right to file a case against to me. It means it is the private wrong where the two individuals are involved. Whereas in the crime, it is a public wrong. If suppose the murder is committed by the person, so it creates the fear in the mind of the society at large. If suppose the theft is committed in my society, so I will not get sleep. Why? Because it is the wrong which is committed against to the publics, where it deter the public, where it creates the fear of the same wrong against me. So we may say that the crime is a public wrong where it affect to the public at large. Whereas under the tort, it is a private wrong where it cause or where it affects to the particular individual who is involved into the particular case. Now, so far the tort is concerned, it is a breach of private duties. What is that breach of private duties? Basically, that is every person in the society having some duties, and these duties is casted by the law, and it is the expectations of the legal system or the law that I am bound by to fulfill that particular duties. If suppose I have breached the duty, say for example, that is I am duty bound to throw my garbage into the dustbin. But if suppose I throw the garbage of the garbage of my house to my neighbors, so it is a breach of my private duty. So I am duty bound to take care of this particular garbage which is I produce in my house. But at the very same time, under the crime, it is a breach of public duty. So you are not supposed to, that is, disturb the breach of the public. You are not supposed to breach the public duties. So whenever the duty is casted because of breach of duty on the part of the person, if it is caused the society at large, if it is caused to the community at large, then we may say that it is a breach of the public duties. Now, under the law of tort, the object of action is a compensation. If you go under the law of tort, so the main purpose to get the remedy is to get the compensation for the loss which is caused to you. If suppose any persons commit the wrong or wrongful activity by breaching his the duty, and which is caused or which is sustained injury to me, so in that circumstances, under the law of tort, I will go to the court and I will demand or I will claim the compensation in terms of money from that particular persons for his wrong or for his breach of duty. Whereas under the criminal law, the object is to punish the criminal or punish the wrongdoers. So whoever commits the wrongful activity, the person is liable for the punishment. So the main aim of the criminal law is to punish the person, whereas under the law of tort, the main aim is to get the compensation in terms of money for the wrong which is committed by the person. Now, under the law of tort, individual has to approach the civil courts. So he may go to the civil courts or the consumer courts or industrial court like that. So for whatever the considering the nature of tort, whatever the tort he has or she has committed, considering the nature of tort, the particular persons will approach to the civil court and he will get the remedy in form or in terms of the compensation or the damages. Whereas under the crime, the state has initiated the prosecution against to the wrongdoer. So basically, you may see that is whenever you refer any criminal law, so it start with the state versus XYZ. What that state means the prosecution or the state has a responsibility to take care of all these particular laws and the legal orders. So accordingly, the state will initiate the action against to the wrongdoer. So basically, who is the first party under the crime? The state, and the second party is the criminal. Now, under the law of tort, the first party is the person who suffer the loss, and the second party is the persons who cause the loss. So basically, under the law of torts, the persons may file the complaint or file the civil suit against to the particular individual who commits the wrong. Whereas under the criminal law, the state has a right to file the case against to the wrongdoer who commit the wrong or crime against to the society at large. Now coming to the difference between the law of torts and the contract. What is the difference between the torts and contract? So again, the tort is where you may get the legal remedy to the victim to recover from the loss or injury or the damages, as we already discussed. So under the law of tort, you will go to the court of law and you will claim the loss, you will claim the injuries, you will claim the damages what we suffer due to the wrongful act of that particular person. And under the law of contract, it is a set of law which can be imposed some terms and conditions. So contract means what? When the one party enters into the contract or the agreement with the other party upon certain terms and conditions. If there is a breach of any certain terms and conditions, so the persons may file the case against to the particular persons for the breach of that particular conditions. Now, under the law of tort, its rights and obligations result from the common law created by the courts. So, as we already discussed, the rights and obligations, rights and duties are fixed by the laws. Whenever any persons breach the duties and cause the loss to the rights of the other person, so the parties has liberty to file the case against to the particular persons into the court of law, which is created by the state. Wherein under the contract, it is the rights and obligations resulted from the agreement between the parties. So the actions will be initiated only when there is a breach of any agreements, terms and conditions, or the obligation which is made between the parties before entering into the agreement or before entering into the contract. So basically, under the law of contract, we are supposed to talk about the breach of obligations, breach of the conditions between the parties which was agreed when they enter into the particular contract. Now, under the law of tort, it is the duties are determined by the law. Why it is determined by the law? Because the law impose the duty on every person, and the person is bound to follow these duties. If there is a breach of the duty, then it leads toward the tortious act or the remedies under the law of torts. Whereas under the contract, it is the parties determine the duties which is created or which is based upon some certain terms and conditions agreed between the parties. If suppose I enter into the contract, so I agreed these particular terms and condition I am bound to do. So whenever there is a breach of the duties, so the how the breach of duties will be determined, it will be determined basing on the agreed terms and conditions between the parties. Now, under the torts, minors can sue and damages are recovered. If suppose any tort is committed against to the minors, so minors has rights. Anybody has right to file the case under the law of tort and can recover the damages or recover the loss which is suffered by the parties. Whereas under the contract, minor has a limited inalienability. As you know, under the Contract Act, the minor is not allowed to enter into the contract. Morbi versus Dharmadas Ghosh case, where the minors has no liability under the contract because minor is not a competent person to enter into the contract. So far minor is concerned under the contract where there is a limited liability onto the persons, but under the law of tort, whatever the wrong which is committed irrespective of age, if the person is minor, if the person is old age, or any individual against whom any tortious act is committed, the parties or the persons has right to get the remedy. And privity must be exist, and under the contract law privity is not needed or does not exist. Now, what is the object of law of tort? Why we are study the law of torts? As you know, the first objective is to what? To determine the rights between the parties to the dispute. So the main objective of the law of tort is to determine the rights, whether there is a rights and whether these rights are violated by any other persons. If it is so, so the law of torts give the remedy to the particular persons. Now secondly, to prevent the continuous or the repetitions of harm. So the main objective of the law of tort is if suppose the person is continually committed the harm or repeatedly committing the harm to the party, so law of tort is supposed to prevent that particular harm. Say for example, suppose any person is commit the torts against me, and file a case against to the particular persons into the court of law, so the court will prevent not to do the certain harms again and again to the particular persons. Now the third objective is to protect the certain rights of every individual recognized by the law. So the main purpose or the main objective of the law of tort is to protect the rights. As we already discussed, there are certain rights and duties which is given by the law. So I have the rights, at the very same time I have the duties, and a particular next person has a right, so at the very same time he or she has a duties. So whenever any person commits the wrong by breaching the duty which resulted to the violations of right of the others, so this particular kind of the things is prevented by the law of tort. So whenever there is a violations of rights of the certain persons or the particular person, so the particular law of tort will give the remedies to us. And the last objective is to restore the one's property to its rightful owner. If suppose any persons take the property of the others in by way of the wrongful means, by way of the wrongful breach of the duties, so the law of torts provides the, that is the rights to take the property from that particular persons. Now, considering the objective nature differences between this particular law of torts and other crimes and other form of the civil laws, so we need to understand what is the definition which is given by the so many jurists pertaining related with the torts. So I just refer the three definitions which is given on the law of torts. The first is what the Salmon says. So, if we read carefully this particular definition, then we are able to understand what the law of tort is. Now, the Salmon says tort is a civil wrong, and for which remedy is common law action for the unliquidated damages. So, what the Salmon says? Salmon says tort is a civil wrong, and whoever commits the civil wrong, he will get the unliquidated damages. That is, liquidated and unliquidated means where the persons may get the, that is the damages the as per the laws or as per the what we as per the violations of his rights. So there is no limitations to how much he or she will get. There is no cap as such. So whenever any persons commits the any activity which leads toward the wrong, so the common law or the torts will provide the damages to the particular parties, and which is not exclusively the breach of contract or the breach of trust or other merely equitable obligations. So it is not the case of the breach of contract or breach of trust, but it is any wrong which is committed by the persons where the persons will get the remedy. Now, second definition is given by the Winfield, where it says the tortious liability arise from the breach of duty. As yes, see the definition of Salmond is also says that there is a duty, and whenever there is a breach of duty which leads to the civil wrong. Winfield says the tortious liability will be arise only when there is a breach of duty. Breach of, if suppose I breach my duty which is primarily fixed by law to me, that is, as we already discussed, that every individual is bound by some duties. So whenever I breach my duty which is fixed by the law, and this duty which is available or which is towards the person generally, so it is not the case where the duty is fixed against to the particular individual. Say for example, so I am not supposed to spit on the roads. So what we see, that is spitting on the road is a primary duty is fixed, ki you are not allowed to spit. Suppose for example, I am smoking at the public places, so what the primary duty is fixed by the law, you are not allowed to smoke at the public places. So what I, if suppose I breach that particular duty which is fixed by law, and where I am bound to follow that particular duty toward the persons in general. And if suppose I breach it, irresponsible by an action of an unliquidated damages. So if suppose I breach any duty which is caused, which is given by the law, which cause harm or loss to the others, so the other person has right to file a case against me for the unliquidated damages. So considering this particular two definition, we may say that tort is nothing but a duty which is fixed against to the person, and breach of that duty which leads toward the violations of right of the others, or which cause loss, injury, damage to the others. So the particular persons may file a case under the law of tort. Now we just refer the section 2M of Limitation Act 1963, where it says tort means a civil wrong which is not exclusively the breach of contract or the breach of trust, what we already discussed. So in short, we may say that the definition given by the Salmon, the definition given by the Winfield, and the definitions given under the Limitations Act, tort is a civil wrong which is based upon the duty, and when any persons breach that duty and cause the harm or injury to the others, so other persons has right to file a case and may claim the damages whatever the loss he has suffered. Now, basically, the tort is based upon these two words, what we call as the actions of the persons. So, what is that actions of the person? There are the two actions. The first is a right actions and the wrong action. Action means act. So, act of the persons. So, whenever I commit any act, from morning to evening, I do so many acts from the, that is, if suppose I ride the bike, so it is a act. So what is my right and the wrongful act of that while I riding the bike? Suppose I riding the bike with the full speed, which is not allowed. If suppose there is a limitations of the speed, that you are not allowed to ride your vehicle above 40 speed. So if I ride the vehicle, so my act is wrong. Why it is wrong? Because the duty is fixed by the law that you are not allowed to cross that particular speed limit of 40. So from the morning to evening, the persons do the so many acts. So these particular acts, to cast the liability under the law of torts, we may divide this particular act of the person in a two way. First, the right act and the wrongful act. If the persons commit the right act, so there is no liability, there is no questions of the case is arise. Suppose for example I ride my vehicle on the allotted side by the state. If I follow the all the signals, if I go with the normal or the speed which is permitted, so these all act as a rightful act. But if suppose I breach that particular principle, so it is a wrongful act. So there are the two wrongful acts. So we may say that the legal wrong and the moral wrong. So far, the moral wrong is concerned where the liability sometimes is not that is not casted on the particular person, because the morality may differ persons to person, situation to situation, place to place, and so on. So sometime for the moral wrong is not what we called as where the person is not bound. Suppose for example there is a beggar. So it is my moral duty, that is whether I give the money to the beggar or not. If I deny to give the money to the beggar, so there is no wrong at all, and the beggar has no right to file a case against me, because it is based upon my morality. But so far the legal wrong is concerned where the particular person is bound to follow the legal principle. So legal wrong is also divided under the two broad categories, that is the private wrong and the public wrong. So far, the private wrong is concerned whenever any legal right is casted on the particular persons, when there is a duty and the rights. Whenever persons breach the duty it to against to the particular individual, what we called as a private wrong. And if it is against to the public at large, then we will call as a public wrong. Now, basically, the tort is based upon the wrongful act of the persons which infringes the legal rights. So, mere wrongful act is not a tort unless and until it infringes the legal right is a wrongful act, but not an every act. So, where there are so many acts which is wrongful in nature, but if suppose it did not infringe the legal right of the particular person, so we can't say that it is a tort. So for the tort, every wrongful act which infringes the legal right of the others, then it is called as within the definition of the torts. Now, what are the elements of the torts? Now, the first wrongful act, as we already discussed, unless and until the act must be a wrongful, the person is not responsible. Secondly, the wrongful act must give rise to the legal damage or actual damage. Mere wrongful act is not suppose, for example, I committing the wrongful act within four walls, where it did not cause infringement of legal right to anybody, so it is not the actionable per se, because the wrongful act did not cause infringement of the legal right to the other persons. So wrongful act only will be considered when it caused the damage or actual loss or actual damage to the other persons. And third is that wrongful act give rise to the legal remedy in the form of an action for the damages, where the other person has a right to file a case against you. So basically, there are three elements under the law of torts. First is there must be a wrongful act. Wrongful act must be committed by the person against to the individual or the society at large. And third, this particular wrongful act must give rise to the legal remedy. When the particular person has right to get the remedy, then only this particular act is within the definition of the law of torts. Now, coming to the elements of the torts. So basically, this is the 3D formula. So law under the law of tort, we may say that there are the 3D elements. What is that 3D elements? The first D stand for duty. So every person has a duty not to cause any harm to others. The second D is default. Whenever you breach your duty, default your duty is equal to resulted to the damages. So first D stand for duty, second D stand for default, and third D stand for damages. In short, we may say that every person is under the duty not to cause harm to others. But if suppose any persons who breach or default the duty which lead damages to the others, which lead injury to the others, then it is called as a tort. So simply we may say that tort is nothing but a breach of duty which resulted damages, injury or loss to the others is equal to torts. Now, what the Indian judiciary says on the law of torts, I just refer the one case law here. That is Jay Lakshmi Salt Works Private Limited versus State of Gujarat, 1994, SCC 41. What the court says, truly speaking, entire law of tort is founded and structured on the morality that no one has a right to injury or harm other intentionally. Again, in this case also, the court is saying that that is the person is under the duty not to cause harm intentionally to the others or even innocently. Therefore, it will be primitive to class strictly or close finality the every expanding and growing horizons of tortious liability, even the social development, orderly growth of the society and culture refines the liberal approach to tortious liability by court is more conducive. So, in short, what the Supreme Court says in this case, so tort is nothing but what we call as a violations of your duty, which leads toward the harm to the others and which cause harm to the others is within the definition of the tort. Now, this the legal damages, that is this particular part we will discuss into the next lecture. So, thank you very much.